So a new case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court. And with Congress's recent activity in passing the $0 tax on suppressors and SBRs within the Big Beautiful Bill, this case just got even more interesting. So let's break down what is happening in this critical challenge. Now, before we jump into the video, if you guys want to support the channel, one of the best ways to do that is simply subscribing to the channel. That, of course, helps the channel to grow. And then also just drop a positive comment down below, and that tells the algorithm that you appreciate this type of two-way content and should share it to more people. Now, as I mentioned in the intro, in this video, we're going to be talking about a new case in a very important NFA challenge that is now in front of the Supreme Court. This case is called U.S. versus Robinson, and it's a challenge to the NFA and its restrictions on SBRs. In this petition just filed by the plaintiff asked for the Supreme Court to find that the NFA's restrictions are in fact unconstitutional under the Second Amendment as they apply to SBRs. This is a case that has been ruled on already by the 11th Circuit Court of Appeals, and in that ruling, the court there found that the NFA does not violate the Second Amendment. They found that the NFA's SBR restrictions are constitutional even in light of the recent Supreme Court decision in Bruin. This has now prompted Mr. Robinson here, the plaintiff, to seek Supreme Court review on that decision. This issue is now even more interesting and important because Congress recently passed and Trump signed into law the new change, which is going to take place in January, so the beginning of next year. And the whole, issue there is the reduction of the NFA tax on SBR suppressors and other NFA items. It's going to take the tax from $200 to $0. So this challenge here aims to remove all of the remaining SBR, restrictions, which would be the registration and all of that, and remove them completely from the NFA by saying that the NFA and the restrictions on SBRs does in fact violate the Second Amendment. Now, the facts around this case are interesting. On September 9th, 2022, law enforcement officers responded to a complaint of a suspicious vehicle parked in front of a house in a certain county in Florida. Now, when officers arrived, they observed that Mr. Robinson was sleeping in his car. He was sleeping in the driver's seat, and then they also shined a light and saw that there was a buttstock of a rifle that was next to him. The officers also woke him up using the flashlight. They asked Mr. Robinson to put his hands on the steering wheel, but then he decided, dumb way, to take off, and so he drove off. Police officers followed him, turned on their lights, and eventually Mr. Robinson pulled over. Once he pulled over, he was detained, and the officers looked and searched into his car, and they recovered a loaded short-barreled rifle, and then there was also a separate upper that was assembled for, a rifle. It was a 60-inch barrel rifle for an AR, and so essentially they gave him his Miranda warnings, questioned him, had some discussion with him, and they found that he recently bought the rifle in Tampa Bay, Florida. They searched the National Firearms Registration and Transfer Record database, revealed that it was not a registered short-barreled rifle to Mr. Robinson, and so then he was arrested for violating the NFA. He was eventually charged and then later convicted after a bench trial, and the district court there found that he was in fact guilty. He was later sentenced to 18 months probation and 6 months served on a home confinement. So he got, 6 months of home arrest, but, he was convicted of illegally possessing an SBR in violation of the NFA. Mr. Robinson then appealed that conviction up to the 11th Circuit Court of Appeals. And on appeal, he argued that the statute here that he was convicted under does violate the Second Amendment in light of New York State Rifle and Pistol Association versus Bruin. And he also argued that the NFA is unconstitutional because it's an unconstitutional tax on a fundamental right, which is the Second Amendment. However, on review, the 11th Circuit rejected all of Mr. Robinson's Second Amendment claims and then also that tax argument as well. They said that that was foreclosed because of Bruin. Now, in its decision, the 11th Circuit not only rejected the Second Amendment challenge, but also the tax argument. On the Second Amendment question, they relied heavily on the Supreme Court's prior Miller decision. They stated that Miller already found that short-barreled rifles and SBSs are dangerous and unusual firearms, and therefore they could be restricted. They believe that there is no meaningful distinction between short-barreled shotguns and short-barreled rifles, and therefore Miller stands for valid precedent, again, also against SBRs. They stated that until the Supreme Court changes that decision or clarifies the whole SBR issue, they are essentially bound to follow Miller in this case and other cases. Now, in rejecting the tax argument, they claimed that Bruin's decision forecloses that type of tax argument since Bruin contemplated that some objective restrictions like fees and tests were permissible in the Second Amendment context. Therefore, they struck down the tax argument and they said that that was not valid and you could not bring that challenge against the NFA. Well, now that decision by the 11th Circuit Court of Appeals is up for review in the Supreme Court. Mr. Robinson has now filed his official petition for Supreme Court cert, and he is arguing the Supreme Court needs to address this issue. In the petition, the two main questions he presents for the Supreme Court to have to address and consider are whether federal criminal punishment of the possession of an unregistered short-barreled rifle violates the Second Amendment, and second, also, whether the federal criminal punishment of the possession of an unregistered short-barreled rifle exceeds Congress's powers to tax under Article 1, Section 8, Clause 1 of the Constitution and violates the 10th Amendment. Now, in their petition, Mr. Robinson argues and essentially rejects the notion that the Supreme Court's prior Miller decision actually stands for the proposition there that SBRs are not protected arms. They state that the 11th Circuit below relied exclusively on Miller, but the court's reliance was misplaced. First, Miller did not hold that short-barreled shotguns were not protected arms. Rather, because the defendants made no appearance in the case, neither filing a brief nor appearing at oral arguments, the Miller court was not presented any evidence tending to show that short-barreled shotguns were protected and declined to take judicial notice that they were. Consequently, the Miller court explained, "We cannot say that the Second Amendment guarantees the right to keep and bear such instruments." Declining to hold in the absence of evidence that short-barreled shotguns were protected differs from determining that the Second Amendment does not guarantee a right to possess them. They go on to argue that second, because the Miller court declined to conclude that short-barreled shotguns were protected arms, Miller stands only for the proposition that the NFA's restrictions are valid as applied to arms that are unprotected by the Second Amendment. But this says nothing about arms that are protected, such as short-barreled rifles. They then argue that since SBRs are protected arms under the text of the Second Amendment, the government bears the burden to essentially prove under Bruin that there is a history and tradition supporting this whole registration and taxation scheme. They state that the government has not met that burden. They point out that the colonial era laws that the government uses to justify the NFA have a completely different purpose. The purpose of those colonial era laws that are used was essentially to make sure that the population was sufficiently armed, not to disarm them like the NFA does. And also the whole how and operation of those colonial era laws were drastically different from what is going on with the NFA. None of them required pre-possession registration or imposed a pre-possession tax on the firearms, so there is no historical support through those colonial era laws either. Because of all this, Mr. Robinson asked for the Supreme Court to grant review to the case and strike down the NFA's SBR restrictions under the NFA. This is a case we're going to be watching very closely, especially now with the NFA tax change from $200 to $0 in light of the passing of the Big Beautiful Bill, which is set to take effect at the beginning of next year. This is now the second NFA/SBR Second Amendment challenge that is currently seeking Supreme Court review and that they're going to have to consider next term. I will note that the Supreme Court has been very hesitant to step in on big 2A cases lately. They recently rejected the rifle and magazine ban challenges last term, so maybe the NFA and SBR challenge will be a little too controversial or high profile for them. I hope that's not the case. The purpose of the Supreme Court is to take these high profile issues. But with the whole NFA tax change, maybe it's going to create a unique enough dilemma and situation that will get the Supreme Court interested and involved in this challenge. So that's what's currently going on with the new NFA/SBR challenge that's in front of the Supreme Court. As it develops, as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to simply like, comment, and subscribe. All those things help to fuel the algorithm, or fuel Al Gore's rhythm, as we used to say. It signals to the algorithm that you appreciate this type of 2A content and that it should share it and feed it to more people. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.